Welcome to Courtroom Insights. Today, Judge Boyd doesn't just hold court, she delivers a dose of reality to someone who brought a brawl to a building lobby. Gracie Sugundo found herself in front of the bench after a shocking elevator beatdown that left her victim injured and the public outraged. What's on the table? A harsh sentence, a $500 fine, and absolutely no sympathy from the court. If you came for accountability, you're in the right place.
During COVID, this woman tried to force her way into a packed elevator. When the attendant said no, she snapped, brutally beating and injuring the victim in what turned into a full-on Royal Rumble. She was arrested, sued for millions, and now it's up to the judge to decide her fate. The sentence, absolutely brutal.
She said, yeah, I got hit multiple times. And I said, well, why didn't you defend yourself? She says, I couldn't because I was being held down.
State of Texas versus Gracie Sugundo. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Javier Oliva and Bradley Bellis for the defense.
Are you Gracie Sugundo?
Yes, ma'am.
All right, according to the plea bargaining agreement, punishment is to be assessed at 7 years in the prison. There's a $500 fine. The state is opposing your application for deferred adjudication. They're recommending community supervision, and there are items to be taken in consideration. Have both parties had a chance to review the PSI report?
Yes.
Any objections to the PSI report, state or defense?
Judge, so there are some errors on the PSI report that we wanted to bring to your attention.
Yes.
So it lists the offense date as, I believe, November 16th of 2021, when in reality, the offense date that's on the indictment is October 16th of 2021.
All right.
And it lists that in the criminal history. There's an assault that was in the criminal history that it makes it seem as if they're two separate offense dates.
Okay.
And then I think in the towards the back of the actual statement itself that Ms. Sugundo gave, there's a portion where it's talking about the co-defendant and that he's charged with ag assault deadly weapon. It's assault SBI. It's the same offense.
Okay.
We just wanted to make sure you were aware.
All right. And the court is also in receipt of victim impact statement. And the court is also in receipt of letters that defense presented on behalf of the
Was to be taken consideration with CC County Court 4 case 69-3701.
Yes, and the court does have that as a part of the plea bargaining agreement. My decision on this case is not going to be impacted by the fact that I know her. So if anyone has any objections to me hearing this, now is the time to say so. State?
No, Your Honor.
Defense?
Your Honor, I have all the confidence.
Right. So before I begin with your presentation, with regards to the case to be taken in consideration, if you could raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record. All right. And with regards to County Court Cause number 6933701, the state is taking that case into consideration, but to that case, how do you plead?
No contest, sorry. I'm just nervous.
That's okay.
We'll go ahead and proceed with a guilty plea, Your Honor.
All right. So to County Court Cause number 6933701, how do you plead to that?
Guilty.
All right. And state, do you have the dismissal
Yes,
for the
Judge.
court in that cause number? Defense?
Your Honor, we're here because one incident can't define a person for the rest of their life. And this is very serious, and no doubt we take that very seriously. This is a felony charge. It's a felony charge that carries a very significant penalty. But Ms. Sugundo, I think, has demonstrated a respect not only to others, but to, rarely do I have an opportunity to where a client will provide 32 letters of reference about how wonderful she is with caring for others. And that is the life that she defines herself with. We just feel like this should not define her as a felon for the rest of her life when she has 4 children as a single mother. We know that life is difficult and it's very, very, very hard. And she's having to raise 4 children on her own, ages 15, 14, 12, and 10. As a single mother, she has to be involved in their school activities and support their activities with FAA. And a felon cannot be associated of 4 children that need their mother so that they can become better than her and have a future. She lives in Houston. She leases a home. She's lived in that home for 3 years. She has good family support. As I've said, her mother and father are present. She has a high school diploma. She has been employed during this whole time. This case is 2 years old, 2 years This week, this happened. And it's been 2 years that she has been experiencing this, and she has complied with everything this court has asked. She's appeared in court. She's traveled from Houston to San Antonio. She has fully cooperated. She has weighed all of her decisions and sought not to seek a trial. And she made that decision because she felt that was in her best interest. This case was very regrettable, and it should have been a day of celebration. She's willing to do the urine analysis.
Don't forget to like the video and subscribe to the channel if you like the content.
She's willing to state no contact, and she's had no issues in the last 2 years with the defendant, the complainants in this case. She's willing to take anger management classes. She's willing to do community service. She's willing to do what it takes to give her the chance. And she has proven, other than this one incident that happened in a flash, wasn't premeditated, it wasn't thought of. It was just something in a reaction and defense of someone that she was with. And for that reason, we think that she should be given an opportunity to earn the right to be able not to be a convicted felon. The amount of restitution in this case, I think we've agreed to, that was presented before the court, was $2,416.29. We fully agree to repay that. We will work hard every day to pay that back.
Well, just so you know, in this court, I see everybody as a human being. I don't see them as their titles. So for me, defendants are not defendants. They're human beings who are accused of a crime. I do not understand how the fact that an elevator has a limited capacity, how we go from people saying the elevator is full, you cannot be in an elevator, to it's a brawl. So explain that to me.
I mean,
there has to be some sort of thought process. For example, if there's an elevator, I think everybody knows there's a weight capacity on the elevator. Me personally, when I see there are too many people on the elevator, I don't get on. But obviously what we are here now for is there's an elevator. According to everything that I've read, the elevator was at capacity and there were already some people on there. I don't understand how an elevator is at capacity, people need to get off or more people can't come on, how that ends up in a fight.
I couldn't tell you how it started. I just, somebody in my party was getting into it, and somebody hit me and I just reacted. And unfortunately, I feel bad and should never have done that. Shouldn't have got to that. It just happened really quick.
I know things happen quickly, but the police report I'm reading, it doesn't say that somebody in your party got in an altercation and you got hit and so therefore you got into a fight. What your counsel is telling me is that somebody in your party, I guess, was in a fight and then you decided to get involved in that fight.
I went to go and try and pull my friend away, and then I don't know, it was just a bunch of people and somebody hit me and I just reacted.
Who she was with, another man and another person, to get off the elevator. That person said, I want to talk to your supervisor. That individual entered into an altercation with the victim's husband that spilled out of the elevator onto the floor, injured Ms. Martinez. And that's what we're here 2 years later doing that. And in addition to that, Judge, there is a civil suit in this case where the parties in this case are seeking $1 million in damages against my client. And so this case will not end today. It will continue in a civil matter with a lower burden fee, where she will have to defend herself in a civil cause of action for money damages.
And Judge, just to clarify from the state's end, I would disagree with the characterization of how the incident started. The party was already on the elevator. The complainant's party was already on the elevator. They were asked to not enter the elevator.
And I also have a copy of the lawsuit that was filed this week before the sentencing, where they're seeking $1 million damages in civil lawsuit. Right here. You want to see it, Judge? It's public record.
I would object just because relevance.
It pleads the whole case, Your Honor. Exactly what you're talking about is pled in the civil suit.
I mean, if that document has facts that somebody has, alleged facts that somebody has presented, that's a different rendition from what's in here, then the court will.
It does not, Judge.
All right. So
just to let you know, there is a civil suit.
All right, then the objection will be sustained. All right. Anything else from either side?
No, Your Honor.
No, Your Honor.
All right. I've read your letters that were presented, and it appears that, other than this one incident, you're a great person, but sometimes sentencing, not sometimes, always sentencing has to do with punishment, rehabilitation, and basically whether or not someone should go to prison or not go to prison. These are all things I have to think about. You understand? And so I have to weigh certain things. And the things that I'm weighing are the fact that there were people in the elevator and you were asked not to get on the elevator. If there are too many people on the elevator, and let's say you get on the elevator, it's a group of you, the elevator is already filled.
No,
Say anything to the court?
No.
Okay.
Oh, Your Honor, may I have one moment?
Yes.
He's had his day in court. He has spoken before the court. I don't see why he needs to speak in this case at sentencing.
All right. You can call your witness.
State calls David Martinez.
All right. You can lower your hand if you'll state your name for the record.
David Martinez.
All right. State.
Mr. Martinez, from your memory, what occurred on that day?
On that day, we were in line to get into the elevator. The capacity of the elevator, of course, as I mentioned, was 18. But because of the COVID era, there was an elevator attendant there. She said only 8 could be allowed in.
I'll let you know if you can continue or not if you have a question about that. That objection will be overruled.
He came in, stood at the door, prevented the door from closing, began to
Objection, Your Honor. I just asked for clarification from the witness. I don't know who he is.
Which he are you speaking about, sir?
her partner. There was 2 gentlemen, which was the initial one that started arguing with us, and her partner that she was mentioning that walked in, and they were not. We were already in the elevator already when they decided to block the door from closing. Can't recall the individual's name, but it was a younger gentleman that was with her. He proceeded to argue with the elevator attendant about, letting them in or not, that it was BS, that they cannot be let in because there was a lot of room, berating us. She was cussing like a sailor, as well as the other ones. We kept quiet, and they started again arguing with us. We stayed in there. The kids were already getting terrified with what was going on. They started crying, and they continued with their vulgar language.
It's something that happened during the middle of your physical altercation, right?
While I was on the ground, yes. And then afterward, I did get up and partially saw my wife on the ground with a bloody nose. She was in a daze, and I asked her what happened. And I told her that she got hit. She said, yeah, I got hit multiple times. And I said, well, why didn't you defend yourself? She says, I couldn't because I was being held down.
Can you say for certainty whether or not Ms. Sugundo was acting in defense of another whenever she got involved in this incident?
I'm going to object to relevance.
All right, that'll be overruled. You can answer the question if you know.
I can't say that, but I can answer.
Oh, and I understand, Mr. Martinez, the want for justice on behalf of the injuries for your wife. I just want to make sure that we're also serving justice here for Mrs. Sugundo today based on her amount of involvement in this incident. And
There was no, go ahead.
Please finish.
No, there was only 2 other parties involved, 3 parties, and the individual who was with me had already left. But it was only her left with her friend, and there was nobody else around. There was people watching. Nobody was getting involved, but they were the only ones actively, physically getting involved.
All right, any other questions?
Nothing from the state judge.
All right, thank you.
No,
All right, any other witnesses?
Your Honor.
All right, the court will hear final argument if there is any.
Your Honor, I think it's clear that Ms. Sugundo did not start this incident, that her actions occurred outside the elevator as a result of defending another person. She doesn't deny that she struck Ms. Martinez, but this was a situation where she was struck as well. And in most cases in sports, that's offsetting. And I think in this case, at looking at the situation, looking at history since that day, that I think it would be fair to give this single mother a chance to continue her life and being a mother and working at her employment. So not to have this crash down on her. So we're asking, Judge, that deferred adjudication be given to this woman so that she can continue to do her life and do good for her children and her work and her community.
All right, so what is the amount of restitution and who is the restitution to? And also in the plea bargain agreement, it says restitution to, and I'm sure if people could go back and change things, sometimes people are serious when they say, if I could go back and change things, I would. Maybe I never would have went to the game. I would have just let the elevator went. I would have taken the stairs. I understand that, but we can't turn back the hands of time, right? That's not playing any factor in my decision. If she did not have that occupation, let's just say she worked at the HEB, for example, then based upon her injuries, she wouldn't be able to work at the HEB. She wouldn't be able to stock. She wouldn't be able to stand and be a cashier. I don't know what they would have her doing at the HEB. You understand? So her injuries are very serious injuries. and I've read the report that was given to me about her injuries, and I've read the PSI report, and I've read the police reports again in this case, because I always like to review things. So I understand that you're very sorry for what happened, but I am where I am right now, okay? All right, this is what the court is going to do. Court will find you guilty, sentence you to 7 years in the prison, suspended and probated for 5 years. There's a $500 fine that will be probated. There's a transfer to Houston, Texas, Harris County. Take in consideration County Court Cause number 693701. There's to be restitution of $2,416.29 to Rebecca Martinez. There's to be no contact with Rebecca Martinez or Jeanette Riojas. Proof of employment within 45 days. There's to be no employment as a home health care provider with minors. 100 hours community service restitution. That'll be waived once you complete parenting classes. There's to be regular reporting by Zoom or in person, regular UAs, and restitution hearing as it relates to Jeanette Riojas. I don't see this as an anger management situation. I see this as an aberration. I think she doesn't need anger management classes. So is there anyone going to object to me not giving her anger management classes?
The state won't object, Judge.
All right. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful? All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So what I've learned in my time on the planet, it's just best when somebody says, oh, you can't do that, and you want to argue about it, pick another date to argue about it. You understand? All right, good luck to you.